Everyone, we're going to go ahead and get started with our community development meeting. Today's date is December 11, 2025. The time is 10:02 a.m. In attendance are Commissioners Eberline, Duncan, and Matari. I'm going to call this meeting to order. Are there any changes to the agenda? No. Hearing none. Poll for conflicts of interest. Any conflicts?
None.
None here. We'll go right into deliberations. This is CUP 25-0009. Canyon Elementary Portable Classrooms. It's an action item, and Justice McGeorge.
Good morning, Commissioners. Justice McGeorge, planner with Community Development. As has recently been custom, you've been supplied with an executive summary for the conditional use permit to establish a school, a non-conforming use as a conforming use. And so as such, I would like to ask if you would like to hear the presentation.
Would you like to?
I don't need to.
No? Nope. Nope.
Okay, I stand for any questions.
Any questions?
No, just a comment that it's the duty of the school district to provide enough seats for students because the Idaho State Constitution says that we will have free education.
Okay, so I take it then that you're leaning to approving this?
Yes.
Yep. Well, with that said, I'll take a motion.
I move that we approve CUP 25-0009 Canyon Elementary Portable Classrooms.
Second.
Commissioner Eberline?
Second.
No, we already
Aye.
got the second. Your vote.
Commissioner Eberline?
Aye.
Commissioner Duncan?
Aye.
Chair Matari?
Aye. Motion carries. Thank you. Next up, business item number 2, mining code amendment above Rathdrum, Prairie, Aquifer. It's a discussion item, and our Director of Community Development, David Callahan.
Thank you, Commissioners. David Callahan, Community Development Director. I'm going to try and pull up a letter and some background information from Suzanne Scheidt, who is here today from the Aquifer Protection District. The reason for this to be in front of you, and I may need Ben to help me with where this is in here. But the reason I've asked to put this in front of you today is we've discovered some situations in the adjoining county in Spokane where open mining development has occurred and penetrated a layer that allowed water to seep up from the aquifer. Thank you. And actually created home sites. You know, this mining area was turned into home sites with access to the aquifer through this, what has now become lakefront property, if you will. That, in my view, is extraordinarily worrisome for the aquifer's water quality. And our current regulations don't prevent that in any way. And so what Suzanne will pull up for you here in a month, thank you, Ben, and talk about is some examples she's seen, if you'd like to go there. But mainly I'm just looking for your consideration to allow us to look at a code amendment. We would do it in the usual way where the staff would draft a concept, take it to the Plan Commission, bring it back to you, all to protect the aquifer.
Thank you. Comments, questions?
Wow.
Yeah, I'm fine with them coming back with some suggestions.
Yep. Okay. So, Director Callahan? You catch
Here's
that?
just an example of a case where they actually did what I discussed for you. But if you're fine with this going, we'll just do it and bring it back to you. Suzanne, did you want to add anything on? No. Okay, that's all we needed. Thank you.
Okay. All right. Next up, item 3, AOI pre-amendment coordination brief. This is a discussion item, and again, Director David Callahan.
Thank you, Commissioners. I wanted this item on the agenda because I didn't want you to be surprised in any way at our next regular meeting. when you consider this, the maps, I mean, for the AOIs next week. And there are also some vagaries of state law that I wanted to cover and give you an opportunity to dialogue again, so you won't be caught by surprise at your public hearing meeting. I'll just start off with a few things that are, frankly, because of the way the law is written, unknown and unknowable. I know that's a rather bold statement, but I'll give you an example. The current law reads, cities and counties shall review their existing areas of impact and shall reestablish these in conformance with the provisions of this section by December 31st of this year. Failure to timely conduct such review and reestablishment shall nullify the current area of impact boundaries and require the city and county to go through the process of Section 2, which is actually, Section 2 is establishing new areas of impact. Well, there are two things that are very problematic with that language. One is, to my knowledge, no city or county can have an existing area of impact because they are all areas of city impact. And so we automatically have this ambiguity out of the chute of what is this law trying to get at? To me, the only logical meaning it can have is when it says area of impact, it must mean areas of city impact. But then that creates another problem where it talks about nullifying the boundaries. In our case, every one of our areas of city impact has text along with it, which is the real meaning of the AOI area of city impact. And so if we don't actually repeal the text, then we have this, and some of these cities, we're not going to actually meet the deadline. Does that mean the text goes away, the boundary goes away, or both? I don't know. I was hoping Pat would be here today to give us his opinion, but he has a family emergency and won't be able to get back to us until another day or so. He might be able to give us a written opinion before your meeting. I hope so. I'll see what we can do about that. But where I'm really going with this is we've made some assumptions based on the only logical reading we can of the code that's in front of us. And so what we've tried to do for your hearing next week is we've made this so that it's only a map. We've advertised that it's only a map. It is not an amendment to our land use and development code. So it does not require what the land use development code requires, which is a 28-day notice. And instead, we use what the state law requires, it's just a 15-day notice. We sent out, as the state law requires, the notice to all of the property owners in the unincorporated county, outside of the city limits, but within the mapped areas of the AOIs. That worked out to be roughly 4,500 notices. The cities have agreed to reimburse us for the mailing cost of that. And they don't, frankly, have much choice because state law says they have to. But just so you know, they've agreed to. And that mailing notice has started to create some people, as you know, that have become very concerned about this, and raises another question I wanted you to have the ability to think about and dialogue with us on today, which is what happens if you choose to let some of the people out of the mapped area, and is that possible? I think the state law doesn't address that question, so therefore I would think you could. Again, it would be good to have Pat's opinion on that, but I think we could handle it in the same way we did with the zoning for the tribe, which you may recall. In that case, you opted out, meaning you let people just choose to opt out of it. I think we could do the same kind of thing where the cities would still keep their boundary map, but you could potentially let people out by parcel number, because that's a distinct known way of exempting property from something. So we could call out the boundaries exempt properties if that was your desire. I'm not suggesting it should be. I'm just saying that I've already responded to 50 of those emails. I'm expecting to get another 150 or so. And I know my staff has responded to several hundred phone calls. So we're tracking somewhere around 3-4% of the total mail out. That's pretty low, but it's still significant, statistically significant. So just wanted you to be aware of that. Another aspect of this is, since we won't be getting all of the cities in this next round next week, that will necessarily be a full-blown text and map amendment for those remaining cities. That will presumably follow the land use development code process. So there'll be a 28-day notice ahead of that. And unless you tell me otherwise, since the land use code requires a planning commission review, normally we'd take it to the planning commission and then you. With the 28-day notice, we can double notice to save a little bit of time between Plan Commission and you. But again, that will be the 28-day notice, not the 15-day notice we just did. Does that resonate for you? Okay. In your package for the next hearing on the 18th, you will have information from Post Falls and Coeur d'Alene. I believe we've gotten it from Hayden. I don't know that we've gotten it from anyone else, but it gives you a rational justification from each city as to why they've proposed the maps they've proposed. So that I think you will find helpful. And the one last thing I can set the stage for, and then we'll turn it over to Dave Christensen or Ben or Craig if they want to add additional things, is that when we got at the maps originally from each of the cities, because each city staff worked up a map for each city, there were some discrepancies between their shape files, which you wouldn't necessarily know. Shape files are how GIS mapping is done, and our shape files. And so property lines and proposed AOI boundary lines weren't necessarily matching up well. So our GIS staff worked with the GIS staff of all the cities. We've come up with what we believe are clean lines, and as I understand it, the cities agree. But at this point, I'll turn it over to Mr. Christensen if he wants to explain where we are at this point.
Certainly. Dave Christensen for the record.
Dave, your microphone.
Dave Christensen for the record, GIS manager at Kootenai County. David Callahan did describe it correctly. The cities provided us shape files, each individual city. Due to mapping and slight variations and reprojections and stuff, the lines were close, but they didn't match up to the data that we utilize here. And so I went ahead and looked through, took their data, started with Rathdrum since they actually provided a legal description for theirs, and started with their boundary, traced it out, have gone through all four of the cities, Hayden, Post Falls, Coeur d'Alene, and Rathdrum. There were a few minor discrepancies. For example, in Hayden, I found one spot where they split a parcel. That's against the state code. Talked with them. We've resolved that. There were some other ones where they sent, I couldn't tell if they were on the north side of the road or they wanted to be the center line. And so we've gone ahead and we've dealt with that. So as far as I can tell, the data that they provided us was close enough for me to interpret their intent. I've gone ahead and made this website that we're looking at here available to the cities to review my work. Unfortunately, I was only able to complete that yesterday. So I haven't gotten any feedback directly from the cities agreeing with the work that I have, but I don't see any major changes. We might have a slight shift from a center line of a road to an edge or something to that effect. But we, I'm fully confident saying that we will not add or subtract a parcel from this coverage that I have into what you will see, unless the cities want something fundamentally different than what they provided me. And so we have this data that we can talk about today. I don't see any gaps or overlaps. The only gap that I see that may be significant in this would be along Prairie Avenue. Neither city, north or south of that Prairie Avenue area, Hayden or Coeur d'Alene, wish to take that in. I don't know how that may affect you guys in the future, But besides that, those 4 polygons do provide a contiguous exterior. The way we're looking at writing these legal descriptions, if we ever had to do that, or looking at this, is we've described the AOIs, their exterior boundaries, and then we will remove any properties that are already inside the city limits. That'll handle any of those island properties that you have. In regards to if you so choose to have people be able to opt in and out, that certainly can be done. We can certainly map that. I agree with David Callahan that parcel in or out is a good way to do that, since one of the requirements is that we cannot split a parcel. Where we may need to take some consideration is what happens in the future if a parcel gets split, because then that parcel number will reside on part of the parcel and not necessarily all of it in some cases. And so not only would we can do the map work based on parcel, but I would clearly denote that the map itself is what would hold and be the legal document identifying what your choice and decisions were. And then potentially if you wanted that modified or whatever, we can deal with those. But that's, if you choose to allow people to, exempt their own property out of that, that would just be some things that we need to consider about how we want to process that in the future. All of it we could do.
Thank you. Any questions? No? Okay.
You want to add anything?
Anybody want to add anything?
I don't know that I have anything at the moment. If somebody else wanted to sound like the people wanted to perhaps chime in, but I may have something that I want to ask later on.
Well, we don't really have public comment, but I guess we could, for the cities, we could certainly take their feedback on that. So if any city representative would like to go up to the podium, just identify themselves and which city they represent, they could provide some feedback.
Good morning, Commissioners. I'm Field Harrington. I'm the City Attorney for the City of Post Falls. I just wanted to touch briefly on a little bit on the statute. I know Pat's not here, and I certainly don't represent the county's position or anything like that. But I did just want to point out, I've been very intimately involved with this 67, 65, 26 areas of impact code, and my interpretation is that it really is just talking about the map, the sort of overlay aspect. It does talk about how the county may adopt individual comprehensive plan and zoning or subdivision ordinance provisions regarding the specific areas of impact. But when we're under this statute, it's really just talking about the maps. And so when it talks about the nullification process and establishing the maps, it's really just talking about the overlay map part of that. So that's all I had to add.
Thank you. Anybody else?
Morning, Mr. Chair, Madam and Mr. Commissioners. Kinzo Mahara, City Attorney on behalf of the City of Hauser. City of Hauser and the county have had a long history of working together collaboratively and in good faith. The city is a smaller city in the county, but it's got a very proud history and a proud legacy of maintaining a very good quality of life in and around Hauser Lake. And just a few years ago, we engaged in a very extensive process in regard to the area of city impact. And the City of Hauser is concerned in that it's not included in the moving forward with the mapping on the 18th. We have worked with the county for months. We understand that it actually went through the Planning and Zoning Commission with a recommendation for approval with, I think, an issue regarding some revenue sharing provisions of the existing area of city impact agreement with the county. Working with the county staff, my understanding, the staff had recommended that for approval. Again, it went through the planning and zoning process with their recommendations to this body, but we would ask that we be included in that that hearing on the 18th, because we would like to not have our boundary disestablished at the end of the year. That is what happens if it doesn't move before December 31st. We put a lot of work in. I know your staff has put a lot of work in. So if we could potentially have that agenda amended to allow ours to go forward as well, the city of Hauser would greatly appreciate it.
Thank you. Is that something that's,
I don't believe that's on the table because we don't have a map from Hauser. The last emails I've sent to Kenzo suggested that we needed to have a map. I further suggested that it need to represent what's currently the Tier 3, which is the one that the current regulations state is the area they are likely to annex into, and that made a rational, logical starting point to me. But we did not get a map back. We did not include them in the notification. And so I don't think we can go forward on the 18th.
because of the notification
Yes, sir.
requirement
Well, and
primarily?
especially because you'll recall the biggest hangup we had at your last hearing was we didn't notice land property owners within the AOI, and we have not done that for Hauser.
And so I'd respectfully take issue with that. I do recall sending a map. I've worked extensively with the city of Post Falls. We had some overlapping boundary issues that we didn't want to have to hash out before this body. And so we were able to do that. And my recollection is that the city, along with Post Falls, did submit a map to the county, and we do have a map. I concur with my colleague's assessment in regard to the state of the law. I believe the remedy under the current statute as changed in 2024, in essence, the remedy of any affected property owner would be to, in essence, ask for compliance with the statute. The statute provides for cities and counties to engage in a 30-day process to, in essence, if there's any problems, to work them out. And I, on behalf of the city of Hauser, would submit that if this body was to approve the map and we immediately began in that 30-day process to work out any hiccups, that would be in compliance with the law, and it would in essence salvage our city's area of impact boundary and allow us to work out any hiccups later.
So if I understand this correctly, what you're suggesting is that we would include the city in the hearing next week, but that there would be this 30-day period afterwards where the property owners could actually weigh in to a degree because we didn't properly notice them for this hearing?
Absolutely. I think there, and I think given the flux of the state of law, and I would concur with Director Callahan that there is a lot of flux in the law or gray areas because this is a brand new law. It's never been tried. And I think everybody here is working in good faith to do the best thing for our joint constituents and the property owners of both the city and the county. I think it would be a burden, in essence, if we were to move forward, at least to the taxpayers and the citizens of Hauser, of both the county and the city, to have to start anew and start these processes anew instead of salvaging the boundary and working through any hiccups through this meet and confer process that's built into the statute.
Well, I understand, but I think without the county's counsel here, it's difficult to have that discussion. But I think what can happen between today and next week is to have a discussion with county counsel and see if he agrees with that as a possible remedy, then maybe we can look at figuring out how to get the city onto that hearing if, the parties are agreeable.
Okay.
And this, Mr. Chairman,
Yes.
I can appreciate where Mr. Mahar is coming from. State law is really specific in that on item 4. It says at least 15 days prior to the hearing, written notice of the hearing to be conducted under this paragraph shall be provided by the county to each owner of property located within the portion of the area of impact that is proposed to be modified. Shall gives us no leeway in that for the 15-day notification.
Yeah. Well, I don't know if we can litigate this here, but I would argue that the county council could work with you on that, and if they can find a way, I think the board, unless I have an objection here, would be open to finding that way as long as it doesn't entangle us, in some other legal issue because we didn't follow proper protocols.
Certainly appreciate that. And again, just noting the long history of collaborative work between the city and the county. Hopefully Mr. Braden will have some time. If not, I can contact Mr. Mortensen and we can hopefully have something for the county.
I do have a couple questions, though.
Yes, ma'am.
One map that I showed had the boundary outside of the 2 miles of the current city boundary. So has that been changed?
I think that goes to the tiering effect that Mr. Callahan discussed. He had sent me a draft. I had sent him a red line provisions, but I think that goes to more of the text versus the mapping. Again, I would note the statute provides remedies for affected property owners if they were to take issue. And at least it would be the city's of Hauser's position is if there were any irregularities of the law, any property owner concerns would, in essence, would not be ripe for adjudication until that process played out and gave the county and the city an opportunity to work through those issues to come into compliance with whatever statutory requirement there were.
Okay, so I'm very much looking at the intent of the legislature, and so I personally won't approve a map that has a boundary outside of 2 miles. And then also, within those 2 miles, will services be able to be provided within those 5 years? So that's very important to me. And the revenue sharing thing, I mean, if you're dropping the narrative and we're just going to do the map, that's fine. But that split, I will not approve that either. So again, I don't know if bringing it forward, if you plan to bring the narrative forward or you're going to do that some other time. But that's very concerning to me. And we have a fiduciary responsibility to the taxpayers of the unincorporated county, of course, as well as the cities, but I wouldn't be able to approve that.
I appreciate your comments, Madam Commissioner, and again, like I said, look forward to working collaboratively with your staff to see if we can get to a place where we can come to this body with a possible solution and go from there. I appreciate Chairman Matari's comment that I don't think we need to litigate these things in front of this body today. Still look forward to working with folks to try to find some common ground to see if we can move forward.
Okay.
Thank you. Anybody else wish to speak from the cities?
Oh,
No?
I actually had one more question. I'm sorry, Mr. Mahara, I have one more question for you. Is the city entertaining any applications or has any plan to annex in the next 4 months?
I don't believe we have any annexation petitions pending, Madam Commissioner. I'd have to look at our planning and zoning administrator's report, but I don't think there are. Ours usually come in waves, usually in larger chunks versus smaller chunks, just because of where we're located in the county. There's still the vestiges of the 10, 20, 40. I think our last major one was like 180 acres.
Okay.
So they come in waves versus the smaller annexation applications.
Okay, thank you.
Thank you.
Thank you. Any other comments?
Commissioners, I have an imperfect memory, but I distinctly remember sending that map to Mr. Mahara and saying, that map does not meet state law. And the other issue I mentioned to you about the Tier 3. And I asked if he'd be willing to rework that map. To my knowledge, we have no such reworking, and that's why I did not include it in the mapping exercise that's in front of you next week, is we didn't have a map that was appropriate to go forward, in my view. And so we have not noticed. So yes, I'm perfectly willing to try and facilitate this with our legal counsel to the extent that's possible. But I think we still need to lock in a map that not only meets state law, but also is reasonable and what the city is likely to annex.
Well, I appreciate that, and I think just, a best good faith effort is all that anyone would ask.
Thank
So,
you.
And again, this is legislative, so if cities contact us individually, that's not a problem. Is that correct?
Right.
Okay.
Anything else on this?
That's it. Thank you.
All right, any comments or questions? No? Okay, well, that concludes our business. 10:31, meeting adjourned.